We're going to go ahead and get started this evening. Hello, I'm Annette Clark, the very proud Dean of Seattle University School of Law. It's my great pleasure to welcome everyone to our continuing series of Influential Voices programs. This is a program in which Seattle University School of Law hosts outstanding legal minds and advocates from across the country. And I just want to start out by acknowledging and reflecting on the fact that we've had such a great series this year. So a particular thank you to our Associate Deans for Research and Faculty Development, Charlotte Garden and Brooke Coleman. Thank you so much for continuing to put these programs together. This evening, the title of our program is Fighting Capital Punishment, a conversation with Cassandra Stubbs, a review of the ACLU's work to oppose the death penalty. So let me start by introducing our very special guest speaker. Cassie Stubbs is the director of the ACLU Capital Punishment Project. That project promotes both abolition and systemic reform of the death penalty process in our country through direct representation of clients, strategic litigation, and public education and advocacy. Ms. Stubbs joined the project in 2006, and since then has served as lead and associate counsel on behalf of death row inmates and defendants in trials and appeals throughout the South, including Alabama, Mississippi, Louisiana, South Carolina, North Carolina, and Tennessee. Her clients have included Bo Jones, a North Carolina death row inmate who was exonerated in 2008 when the state dismissed all charges against him, and Richard Taylor, a severely mentally ill man who was sentenced to death after a sham trial in Tennessee, but who won a new trial on appeal and was subsequently sentenced to life imprisonment. Ms. Stubbs also worked with numerous organizations and ACLU affiliates to file amicus briefs in capital cases in state and federal courts around the country. She's written many policy papers, editorials, and blog posts on a wide range of capital issues, including the persistence of racial disparities in capital punishment and the fundamental flaws of purported claims that the death penalty actually deters future murders. It's also such a great pleasure to have interviewing and carrying on a conversation with Ms. Stubbs this evening, Deborah Ahrens, our own professor of law, who teaches and writes extraordinarily well, I might add, about criminal law, criminal procedure, and evidence. I just learned that Ms. Stubbs and Professor Ahrens went to law school together, so they go back a while. And obviously, Professor Ahrens has a great deal of experience with regard to criminal justice reform. She was a legal fellow at the ACLU's Drug Policy Litigation Project, an assistant public defender in South Carolina, and her scholarship focuses on contemporary policing practices, criminal sanctioning regimes, with particular emphasis on drug policy, as well as the reforms necessary to ameliorate the consequences of our failed experiment with mass incarceration. So we have a great program planned for you this evening. Let me now turn it over to Professor Ahrens to get us started.
Okay, and that is actually almost 100% accurate. I don't think I'm revealing private information here, Cassie. I've actually known Cassie since college. So we really go pretty far back. And one thing I have to tell those of you here who are law students, one of the most humbling things you're going to find as you progress through your career is watching your law school classmates progress through theirs and seeing just the incredible things that they accomplish. And, finding out when you are preparing to ask them questions that they were involved in things you didn't even know that they were involved in. So I am really honored and excited to have Cassie here today. So Cassie, the first question that I have for you, which again, I don't think is revealing anything private, but again, we have a lot of students here, who are soul searching about what they want to do with their lives. And I don't think you went to law school with the original intention of becoming a death penalty attorney. So I was hoping you'd be able to talk to us a little bit about how you found yourself at this project and in this position.
Sure. So, well, first, it's Thank you so much for the invitation, and it's great to be here and really fun to get to have this conversation with you, Deb. That's 100% right that I did not go to law school thinking that I was going to work on the death penalty or even criminal justice issues. I had been a union organizer, and I had done some public health work in the area of environment and labor, and I absolutely was going to law school to do public interest law, but I was very committed to kind of a civil litigation path. And I intended to do workers' rights litigation, and was excited and enjoyed hearing a number of speakers at the law school who talked about the need for criminal justice reform. But it really wasn't until I went to see Bryan Stevenson speak that the thought of doing death penalty work kind of hit my radar. And for anyone who knows Bryan Stevenson, that will probably resonate for you. Why listening to him speak might be a life-changing kind of moment. And if you haven't, I definitely recommend looking for his TED Talk. But he is a really wonderful and compassionate lawyer and professor and visionary person who runs, among other things that he does, a law office in Alabama, a nonprofit in Alabama, where he works with death row prisoners. And so eventually I took his class, then I took another class, and then eventually I ended up doing his clinic. And even though my career kind of took a winding path where I did do workers' rights work, and I did work for a terrific legal aid office in Los Angeles, and then I was a public defender for a while, and then eventually came back to capital law. I was really struck by the similarities in those jobs more than the differences. I mean, the differences are obvious, and I think there's a lot, at least in my memory of law school, there was kind of a lot made about this like path between civil and criminal work as a public interest lawyer. But so many of the skills, the need to do client-centered work, the need to do compassionate listening, the need to be creative and fearless and brave, those things cross civil and criminal public interest lawyering in my experience.
Okay, well, and as you know, my great regret from law school is I did not take any of Bryan Stevenson's classes. So again, for those of you who are students out there, if you have those kinds of opportunities sitting at your feet, go take advantage of them. I wish I had. So we had, when we were kind of formulating, and I know you weren't necessarily involved with this, a title for this, we titled it Fighting Capital Punishment, because we decided that was definitely something that you would be on board for. But that suggests obviously that there's something wrong with capital punishment such that it needs to be fought. And there are obviously a lot of problems a person might have with it, whether those are religious issues or moral issues, or just this is beyond what the state ought to be able to do sorts of issues. But I wanted us to try to focus this conversation, because I know that this is what a lot of your work is focused on, racial justice issues. So I wondered if you could talk to us a little bit about, and obviously this is a big question, what is the problem with capital punishment? Why are you invested as a project in trying to curtail it?
Well, I think as a project and certainly as an organization, the ACLU has long been opposed to the death penalty, and a huge part of that does go back to the way that it's applied, and the fact that there is no death penalty separate from the history of racial terror and lynching in this country. There is no death penalty independent of racial disparities. There's no death penalty that exists outside of that legacy. The problems with the death penalty are we've seen now in 40 years of trying to tinker and change and make this fair or that fair with this reform and that reform. It is a unequivocal failure. It does not accomplish its goals, its purported goals of retribution and deterrence. The deterrence scholarship has turned out to show that the aims of the folks who introduced capital punishment, or at least who argued for capital punishment in the legislatures, that just has not turned out to be true. But I think when we look at why so much of the public is turning from the death penalty, there's no question that the innocence movement, the work around documenting the ways in which our criminal justice system convicts the innocent, really at all levels, of course, but when we see the huge number of people who've been exonerated, who were convicted and sentenced to death and came near or were indeed in some cases likely executed despite being innocent, that is an issue that really moves people across the dial. It moves the dial for people across the political spectrum, across the country. There's just no, it is very, very difficult to say, I'm willing to tolerate the sentencing someone to death and executing someone who may be innocent. I think there have been a number of other reforms in recent years and areas of support that are important to the movement of capital punishment. And one of those is the growing recognition in this country that the way that extreme sentencing and mass incarceration dehumanizes people and gives up on the chance of rehabilitation, or the idea that people are bigger and better than their worst act and can change and evolve as people. So I think that's one area where I'm just really encouraged that we as a country are really kind of reckoning with that as a moral failing of ours, and that we see playing out across the criminal justice system.
Okay, well, just before everyone arrived, we were talking a little bit about the fact that you were here for the State versus Gregory arguments. And some folks here are going to be familiar with State versus Gregory. That was our landmark state Supreme Court case in which our state Supreme Court declared our death penalty to be unconstitutional, and hasn't really looked particularly eager, our state legislature, to give us a new one. So it's, I think, fairly safe to say that our death penalty here is eliminated. And so I was hoping you would talk to us a little bit, because that was obviously a case that did involve thinking about the disparate impact of the death penalty by race, by geography, and so forth. If you can talk a little bit about what the strategy was there, what you were trying to get the court to do, what the court did. I mean, what were they responding to there? Where is the racism coming from in the death penalty?
Yeah, absolutely. So, stepping back for a minute, we see that every empirical study of the death penalty and some aspect of the death penalty has shown the ways in which race plays a role. And one of the ways, for example, is in the charging decisions. Who will be charged with the death penalty? Who gets sentenced by the death penalty? Who do juries sentence? And then, of course, there are a number of other areas where we see race playing out. For example, in jury selection, there have been a number of studies of jury selection that show that the process of how you select a jury in death penalty cases is even more skewed than most criminal trials. So a lot of criminal trials, you see prosecutors using peremptory strikes to whiten the jury pool, so that the jury pool that ultimately decides people's guilt or innocence does not look like the community. That problem is much more extreme in capital cases because there are so many more peremptory strikes, but also because capital juries are rigged. They are, by design, you cannot have a jury where people who are deeply opposed to the death penalty sit on the jury. We have a whole body of case law that says if you're opposed to the death penalty and you're not willing to consider it, then you will not be eligible for a juror. And the net effect of that is another layer of discrimination. It's another way in which fewer people of color serve on jurors, oftentimes fewer women serve on juries. So, but putting that aside, getting back to the Washington, what had happened in Washington that was fairly unique in the country was that Washington had these trial judge reports. So data is part of why we don't have as much empirical data as you would think about something like the death penalty is because there's not great record keeping. But Washington state required trial judges to fill out these reports. And so because there were in every capital case, where there was a first degree capital trial, a trial judge had filled out the report, there was this robust data set. And these researchers, Beckett and Evans, were able to come in as statisticians and do a study and show that there was in fact race of defendant discrimination in jury sentencing in Washington. A Black man was 4 times as likely to be sentenced to death in Washington using the data that the trial judges themselves had entered about capital trials. And so what part of what the Washington State Supreme Court was grappling with was this record of enormous geographic disparities, racial disparities in application of the death penalty in Washington, and whether or not under Washington's Constitution that could stand up and be constitutional. There had really been one other state Supreme Court that had done so in such a robust way, and it struck the death penalty under the state constitution before then, and that was the state of Massachusetts. When Massachusetts said, as a matter of judicial notice, taking judicial notice of the fact that the death penalty is racist. And I think, to me, this is one area where we see not so much that there's change in that the public, much more of the public knows that the death penalty is racist. We've known it for a long time. But what we really see is a lot of change in how tolerant the public is. When we look at public polling, it is more frequently cited as a basis for why we should and need to do things differently, these racial disparities. And so the Washington State Supreme Court just wrote this incredible opinion that I really recommend reading if you haven't. The Gregory opinion is a very strong articulation of why under the state constitution, that kind of discrimination is not constitutional.
And I guess one of the kind of follow-up questions I would have is when I talk to people about what they think is the worst federal Supreme Court decision of all time, McCluskey is probably the decision that I hear most often, although they're talking to me, so that might be part of it. And that was obviously a case where the litigants took really the same approach with pretty much the same statistics, right? And this is, 30, 40 years ago, the exact same 4 times more likely to be sentenced to death. Do you think that the times have changed? Do you think that this genuinely is just a difference between the Washington state constitution and the federal constitution? Is this something that you think can work as an argument in other states?
Yeah, so we have, I mentioned Massachusetts, they, under their state Supreme Courts, went a very different way than the US Supreme Court went. And I think, one of the things that I think about when I think about McCluskey is the language from McCluskey where they talk about how the racial disparities were inevitable. And, that is some of the most demoralizing pronouncements that I can think of in US Supreme Court case law. And I think when you look at the decision from Gregory and you look at the decision later, the Connecticut State Supreme Court, which had also rejected McCluskey under its state constitution, and there was some percolating litigation in Connecticut that was very similar to Washington's. It was on behalf of everyone on the row, they had a study of race and the death penalty, and like Washington, it was a relatively small data set, so in some ways easier to track the numbers than some of the larger states. But the Connecticut State Supreme Court also issued an opinion, and like the Washington State Supreme Court opinion, they also use the language of inevitability, but they use it in the opposite way from the US Supreme Court. They use it to say, we've had the death penalty now for 40 years. We haven't been able to address this problem. It is entrenched. It is unconstitutional. This is discriminatory under our state constitution. And really, I think their states are showing us the path forward to deal with the shortcomings of McCluskey. And we saw in North Carolina, the legislature passed a law called the Racial Justice Act that you might have heard of. The more recent version passed in California, which is not only applies to capital cases in California, it applies to all criminal cases. But both of those laws explicitly say you can use statistics. And you can use statistics to prove, and our direct runs at McCluskey. And I think all of us who are advocates of the criminal justice space hope that we will see the day when McCluskey is no longer Supreme Court law. But until we get there, state courts, I feel more optimistic that we will see more state courts move in the right direction.
Yeah, it's funny. I think everyone has their least favorite part of their least favorite decisions. And I agree with you. The inevitability is part of it, but kind of attached to that, the passive voice, right? That mistakes will be made and discriminations will occur as if those things aren't coming from anyone or any place, right? Is I think maybe my least favorite part of the reasoning in that decision. Well, you had mentioned the Racial Justice Act, and I know that that's something that you have worked on litigating a number of cases under. So I'm hoping you can talk to us a little bit about that approach, because that's a statutory approach, right? That's not courts coming up with constitutional violations. That's a state legislature saying, we see a problem, we're going to try to fix it. So if you could talk to us a little bit about what the reasoning was behind that act and what the litigation has been, I think we'd love to hear about that.
Yeah, so I have a few slides here. I'm just going to share my screen. Let's see. Sorry, 1 second. Well, let's see. So I am sharing my screen. This first slide is actually from the Washington State Supreme Court, and actually, I think that before we start talking about North Carolina, it's worth listening to, if I can get it loud enough. This is a really fantastic argument. And the way that this happened is they had oral argument in the direct appeal case about a whole number of issues, including the constitutionality of the death penalty. And my boss, Jeff Robinson, argued as amicus on behalf of a brief that we filed on behalf of a really broad coalition, including a number of retired judges from Washington State. And this is a question that the Chief Justice asked them.
Based upon that, which we've had since 1985, that it results in a disproportionality of people of color being incarcerated. So does the argument that you're bringing forward today regarding the constitutionality of the death penalty apply equally to our Sentencing Reform Act and the approach that we take to sentencing generally? If not, why not?
I may be back here on another case.
That's what I'm trying to understand.
Because to be as honest with you as I can, of course it applies equally to the entire criminal justice system. We are not perfect. And there's nothing about America except our delusion sometimes that has to make us feel like we have to be perfect in everything. The criminal justice system is not perfect, and the racism that affects it and impacts it is significant. And the sentencing scheme you're talking about is infected with it completely. That's not what's before you today. And we can still try and work because we clearly need a criminal justice system. But if we're talking about who lives and who dies, especially with the legacy that we have in this country about race and the death penalty, I'm asking you to think about strange fruit hanging from poplar trees. Because for many people in this country, that image still resonates with the death penalty in America.
So before I talk about this picture here with the North Carolina Justice Act, part of what I love about that segment between the Chief Justice and Jeff Robinson is that it goes to the link really between the entire criminal justice system and over-incarceration and the death penalty. And I think the very special role and pernicious and dangerous role that the death penalty has played in symbolically and painfully perpetuating racial bias, but also in extreme sentences. And at the same time, what I loved about Jeff's answer there is that this doesn't mean that anyone accepts racial discrimination in misdemeanors. It doesn't mean that it's okay that we see racial disparities in felony murder, that we see it in robberies. We need to do this work. It's the opposite of the answer from the McCluskey about too much, the fear of too much justice. What if we start taking it on here? Won't we have to take it on everywhere? Yes, we do have to take it on everywhere, but we can and should start here. So turning back to this picture from the Racial Justice Act, these were 4 men here. Bo Jones, my client at the end is seated there at the end, who was exonerated after he'd been on death row for several years, as were all of the 3 men next to him. All 4 men had been capitally tried. 3 had been sentenced to death and were on death row in North Carolina. And Daryl Hunt, there's a really terrific documentary on HBO about Daryl Hunt's case. He was a remarkable social justice advocate and racial justice advocate. But the four men went when North Carolina was considering passing a law that said that if you could prove racial bias at the time of your death sentence, then you could set aside your death sentence. The 4 men went to the legislature, and I truly believe that this proximity, that the legislators hearing from these men tell their stories of their exonerations, tell their stories of being on death row as innocent people, played a huge role in how North Carolina, a southern state, became the first state to have a robust law that essentially overturned McCluskey. After the law passed, sorry, I'm trying to turn the screen share off here. After the law passed, we had a 1-year filing deadline. So there were 140 people and over 140 people in North Carolina's death row, and they had to prepare enormous statistical claims, post-conviction petitions within 1 year. And so that was a real challenge. And 2 wonderful researchers from Michigan State University, Barbara O'Brien and Catherine Grosso, undertook not just 1, but 2 large studies, one of which was of jury selection and one of which was of charging and sentencing. The charging and sentencing study found, very consistent with the McCluskey case and a number of studies, that the race of the victim was a huge driver of when the death penalty was imposed in North Carolina. They also found enormous evidence of race discrimination in jury selection. It didn't matter what county, it didn't matter the race of the defendant. There was a lot of evidence of race discrimination. And those were some of the findings that I would say I did not anticipate. How robust those findings would be. This is our heat map. The areas that are in gray are not, that doesn't mean there was no, the areas that were, the areas that were gray don't mean there was no discrimination. That just means that there were too few people of color in the veneers for them to look at the level of discrimination. But these were the ratios that prosecutors struck Black jurors compared to all other jurors. So the yellow, 1.2 to 1.5, to put that in perspective, secondhand tobacco smoke is a relative risk ratio of 1.2. So when we talk here about threefold discrimination, the red, all of these counties that had threefold discrimination strikes against Black jurors when compared to other jurors, we're talking about very large scale, enormous discrimination. One of the other things that we did was that we got discovery of how the prosecutors, what trainings they attended and how they were taught to litigate Batson. And one of the trainings that they attended was called the Top Gun training. This was a regional training where prosecutors from multiple states attended, including North Carolina. And at this training, they got a handout. So for anybody who's not familiar with it, the way Batson works is, under this case law, it's illegal to discriminate based on somebody's race or gender. And so if you think that a prosecutor is is questioning a juror and has moved for the exclusion of that juror based on their race, then you say Batson, and then they have to give a race neutral reason. Here, they literally had a list of 10 cases of 10 categories that they were supposed to read from if they were stuck to try to justify why they were striking a juror. In one case, a prosecutor moved to strike a Black juror, and she said that it was because of the juror's age. The judge in that case, not the defense lawyer, but the judge, noticed that a white juror who she had accepted, had been born on the exact same day. It turns out in that case, after we got this list of top 10 cheat sheet explanations, that she had been reading from verbatim, word for word, from the cheat sheet. So there was really just, I mean, there are just a huge number of examples of the more we looked, the more we found under this new broad law that allowed us to examine the role that race played in North Carolina.
Astonishing to see that on a slide. I have to say that somebody actually typed that up and wrote it down. One thing, and maybe this is obvious to everyone, but maybe you can talk to us about obviously you don't want racial discrimination to occur in jury selection because racial discrimination is in and of itself an immoral act. But why does that matter to the outcome in death penalty cases? Why is that having an effect?
Well, I think there are two layered questions there. One is, why does the prosecution have an interest in trying to strike jurors of color, and in particular Black jurors? And that, I think, has a lot to do with unconscious and conscious biases of the prosecution in general. And I think some of it was training. As disturbing as this cheat sheet is, it has nothing on that training video from Philadelphia, from the prosecutor in Philadelphia, who's seen on video coaching and why the prosecutors in the office, it's their job to get rid of jurors of color in very discriminatory language. And I think the thing to keep in mind is about all of these training documents and training videos is that even if those senior prosecutors have retired and are not in the office, the whole generation of attorneys who they trained, by and large, are still there in a lot of these offices. So as part of it is that there's this culture, it's really just this open secret that prosecutors will and do strike jurors of color. What I found really fascinating was how often they did that. They struck jurors even when the jurors gave explanations that would have indicated they would have been pro death penalty. They would have been pro prosecution. So in that sense, it's not, it's not necessarily strategic on their part if their ultimate goal is just to achieve a death sentence. But as a defense attorney, you want to vindicate your client's right. It is extremely demoralizing and disorienting and undermining of the concept of fairness to walk into a courtroom as a person of color and have no other people of color in the courtroom, which is an experience way too many of our capital clients have had. Who is in North Carolina, almost a huge number of death sentences were secured by all white or nearly all white juries. But then there's a ton of research that actually, no matter what side you're on, prosecution, defense, this is not a good outcome from a from a fact-finding perspective. So in addition to the harm that it does to our civic institution, that it does to the credibility of the court system, we know that less diverse juries deliberate less, and they deliberate worse. They don't engage with each other as much. They don't engage with the facts as much. And there's a lot of empirical research about the importance of diversity and experience, and the importance of diversity and race and gender for making better juries.
Yeah, no, I mean, when I was in practice, if the jury was not out for very long, you knew that they weren't really talking about the case, and you didn't necessarily know what that meant, but you knew that it didn't mean that they were really having a robust discussion like you might hope. Well, I was hoping you might be able to talk to us a little bit about other strategies that maybe your office has taken or is taking going forward to curtail the death penalty, maybe with a jury social justice focus, but maybe other strategies also. I know you've worked on a lot of cases.
Yeah, well, one area where our office has spent a fair amount of time is trying to work in outlying jurisdictions, so counties that are overly active on the death penalty, either because there's a prosecutor who is seeking the death penalty a lot, or because the defense bar is not as well resourced or trained as it needs to be. And so we've gone at that problem from both ends, tried to consult and provide resources and training to the defense bar in those counties, and also tried to highlight the failings of the prosecutor when we see overzealous prosecutors that are out of step with the kind of that seek the death penalty too much and too often. I think one case that's going on right now in the Kansas Supreme Court, the Kansas issued a decision under their constitution that said that the right to life and liberty is unenforceable and subject to strict scrutiny. And so the death penalty lawyers who represent men on death row in Kansas asked the Kansas Supreme Court for permission to brief that issue that was raised in the context of abortion cases. They asked for permission to litigate, to brief that issue with respect to the death penalty. So the Kansas Supreme Court is right now considering the constitutionality of the death penalty under the Kansas Constitution. So that's another example of where we've filed an amicus brief along with a number of other groups in Kansas, similar to the work that we did in Washington under the Washington State Constitution.
Okay, I had one more question that I was going to ask you, and then I see that there are questions that are popping up in the chat. And so I will ask those on behalf of other folks in just a moment. But the last kind of question that I wanted to ask is kind of related to what litigation you're working on. And I often think about, and it kind of dovetails with the idea that there are some prosecutors who seek a lot of death sentences and some who don't, and a lot of what you get is kind of dependent on your race and also your geography, just who's your prosecutor and where do you live. And I remember that dissent that Justice Breyer wrote in Glossop, where he said, look, effectively there is no death penalty in the majority of American counties. It's just a handful of really zealous counties. And then I look at things like Virginia deciding that it's going to abolish its death penalty. And I'm wondering, are we going to have a death penalty in a few decades? But then, I was a public defender in South Carolina, and I think a lot of folks here in the audience know that the state legislature there is considering legislation to reinstate firing squads and electric chairs. So that's a different direction. What do you think is going to happen with the death penalty in the next few decades? Because some of the questions I'm about to ask are going to be kind of about students preparing to do this kind of work. Is this work going to exist 20 years from now?
Well, I certainly hope not, but also more than I hope not, I will tell you that I'm working on my resume, that I see the end of the death penalty on the horizon. When we look at the benchmarks for when the death penalty will be unconstitutional under the US Constitution, we're really starting to hit so many of them. We have, at this point now, with Virginia and the 3 states in moratorium, we have half the states that officially will not allow executions. That's just a sea change from 15 years ago. And as Justice Breyer points out, it's not just who has it on the books, it's who's using it. And not only is it an vanishingly small number of states, it's a small number of counties, it's a small number of outlier prosecutors that are really driving it. And you can't look at a state like Virginia that executed more people in America than any other state, one of the top 3 in the modern death penalty era, a state that actively carried out executions, while I was in this job, and not see its abolition as a major sign that the end is coming. I think, when we look at things like bringing back the firing squad, South Carolina is not the only one to think that that's a good idea. I think what that tells us more than anything is that lethal injection is torturous and a massive failure, and that the methods of execution, like everything else, are flawed with capital punishment.
Right, and that people have kind of deluded themselves into thinking that that's a safe, humane way to do things, when the reality is not so much. Well, so I am going to go ahead and look at some of these questions over here. And one of the questions, and I think that this is something I would love to hear about because I've never done death penalty work, but I've cried in my office about misdemeanor marijuana convictions. So one of the questions that's asked over here is, you alluded to the emotional toll that death penalty work can take. What can death penalty lawyers or other lawyers working with clients in crisis do to sustain themselves in their work? And that's a question I get from a lot of students who are interested in doing the kind of client-centered public interest work that you're talking about.
Yeah, I think that is a question that we as a field are struggling with. I can tell you that it's a question that I personally find really challenging. This job is hard. It's emotionally really hard. And what I think this past year in particular, it's been hard because there were a lot of high profile, the federal executions were really difficult. And the things that make this job so worthwhile, and that for me really combat the heaviness of it, the joy of connecting with my clients' family members, with seeing my clients, with being part of a passionate and collaborative and creative team. A lot of that is so much more challenging this year in the remote era world. But I mean, I think that as a bar, we're trying to learn about, you don't go to a training now without seeing a session on trauma, and you don't go to, it is far more common to see yoga on the conference agenda than it was, say, a decade ago. And I think that there is recognition that we have, in order to be present and responsive to our clients, we also have to prioritize and take seriously the self-care needs that this work imposes.
Right, and do so maybe in healthy ways, unlike some of the ways some of my colleagues used to do. Well, I have another question in here that you've landed yourself right now in a Jesuit Catholic institution for this event, and we have a question here. There's obviously, a religious component to anti-death penalty work too. What is the role, maybe, at least that you've seen, of Catholic institutions in advocacy in this area?
Just one example that comes to mind, Catholic Mobilizing Network, they're on the amicus brief that I talked about in both Washington with the ACLU and Catholic Mobilizing Network are together there and also in the Kansas brief, I think they do really terrific organizing work around the death penalty. And I think I personally have seen a shift as a result of the stronger statements from the Pope. I think, at the same time that there's, ever continuing growing evidence of innocence, which we know has power. And at the same time that the memorial and museum in Alabama have shifted the conversation and the national recognition around the need to take seriously the death penalties linked to racial terror and violence. There are a number of key pieces when we look at the massive shift in public opinion on the death penalty. But I do think that the organizing and conversation and by faith organizations, including Catholic groups and leaders, has made a significant difference.
Okay, so I'm looking at some of the other questions, and one I imagine you probably knew you were going to be asked, which is, if you're thinking back to your law school experience, what kind of advice would you have given yourself as a student? Since we have students here who are going to be interested in hearing from someone who's been very successful doing something they care about, what can students do to put themselves in that position? Are there things you wish you had done differently, or what advice would you give your law school self?
So, well, I think that we opened with one thing that I did well and that I would recommend to you, which is seek out people who you admire and who are passionate about their jobs and who are doing them in a way that is exciting and that you want to learn from, even if it's in an area of law that you hadn't thought about, whether that's elderly law or disability rights, whatever the public interest field. I think the most important thing, both actually for being a law student and being a young attorney, is getting good mentorship. Getting excellent training is really far more important than any substantive area of law. And I think, I was in a public defender office where I had a huge volume of cases, and I learned a lot from being on my feet, but it was a very painful way to feel myself not giving my cases the time and attention that I wanted to, and also the amount of self-teaching that had to happen. Somebody who is facing very real stakes is at the opposite end of that learning curve. And that's not a good feeling. So I would not recommend that approach. And that's not, I really liked the head of my office. It was not his fault that the state of New Mexico was underfunded the indigent defense service. But I do think that as a young lawyer, that's, it made it very clear to me that in my next job, I wanted lower caseloads. I wanted better supervision. I wanted supervisors who had time built into their job, where part of their job description was supervision.
Yeah, and I think that that's not something I thought about when I was in law school at all. And my first public defense job, 325 felony clients usually at a time. It was great. That with wonderful people in the office, but you're right, there's only so much mentorship you can get under those circumstances. Well, I wanted to pick up, this is my question, but I wanted to pick up on something that we talked about very briefly earlier, and Jeff Robinson has mentioned in oral argument, which is you've made these really great arguments that have been successful to challenge racism in the death penalty and the disparate impact. Do you think that that's going to get extended to other areas of criminal law? Because you're right, that's one of the sections in McCluskey where it's basically the Breakfast Club. If we get up, we'll all get up, it'll be anarchy, right? That if we were to find the death penalty to be unconstitutional on racial grounds, then it means that probably all of criminal justice is suspect. And you heard everybody, Jeff, say, yeah, that's right. So do you think that that's something that's going to succeed as an argument outside of the death penalty? Or is that kind of concern about things like innocence and the dramatic stakes, the literal life and death stakes of capital punishment, is that driving courts to a different result than you think that they will reach in a non-death penalty context?
You know, I think it's part of why I'm so interested to see what happens in California. It's certainly the most ambitious legislation in the country that really tries to break and say, like, to break the link between racial disparities in the criminal justice system, and to say that they will take very seriously that problem and insist that there be redress for that problem. When we look at all of the ways that our criminal justice system is so extreme, there are huge areas of reform that you could imagine if you just rewind time and go, back before we had such an explosion of LWOP sentences, for example, life without parole sentences, for example. And so I certainly think, even if I expect to see more court systems grapple with and impose reforms all the way through. And then I do think that we can and should expect courts to do something especially in extreme sentences like life without parole sentences around these racial disparities.
That is uplifting, hopefully. So I guess the last question I'm going to ask you, and then we will draw this to a close, is you had said you were, maybe if the death penalty comes to a close effectively, you'll be revising, and you're maybe revising your resume. Now, what would you be doing if you're not doing this?
Well, that is a good question. I really love doing workers' rights work. When that was the work before I did public defense work, I worked with low-wage workers in Los Angeles, garment workers, day laborers, and I think I am torn between whether I would want to. It also seems really fun to me to go do some criminal trials that were not capital, that don't carry quite those stakes. So I think both criminal defense and employment law are appealing to me.
All right. Well, I want to thank you again for joining us. I appreciate it so much that you were willing to share your experiences with us. And I guess with that, we will draw the event to a close. It's awkward. Like, there should be a pause, and now there's a P. And so I feel like I should put up a little sign that says nothing more to see here. Thank you again so much for joining us. And thanks to everyone who is here to share and to listen.